Hello, welcome back to Legal Brain. In today's class, I'm going to discuss yet another important area, and that is antitrust law in the UK. So I'm going to discuss antitrust law in UK. So you can just look into the screen and try to understand. So before discussing antitrust laws in the UK, I have to start the class from Brexit. So the UK left the European Union on 31st January 2020, and the Brexit transaction period ended on 31st December 2020. And on 1st January 2021, the UK and the European Union became two fully distinct regulatory, legal, and customs territories, and whose relationship is governed by the Trade and Cooperation Agreement, that is TCA. So for basic knowledge, I would like to say this. And now in UK, the CMA, that is Competition Regulatory Authority, enforces UK competition law. So in the UK, CMA is the authority, Competition Regulatory Authority, that enforces the UK competition law. And the CMA has replaced the Office of Fair Trading, that is OFT. And also in UK, this CMA and the Competition Commission, CC, is the primary enforcement body in the UK. So when it comes to UK, antitrust laws, you have to keep in mind about Competition Regulatory Authority, UK Competition Law, and Competition Commission. And now I would like to, speak in detail about Competition and Markets Authority, CMA. What is that and how it regulates the antitrust law in the UK? So the Competition and Markets Authority, CMA, is the competition authority in the UK, which enforces UK competition law and issues guidance on anti-competitive and abusive practices. So the CMA investigates potentially anti-competitive and abusive practices. You have all know about abuse of dominant position, anti-competitive agreements, and so on. So CMA is having the authority to investigate about all these things on its own initiative, that means suo motu, or after receiving a complaint. So this both two possible ways are there. And the CMA has broad investigative and enforcement powers when it comes to the regulatory mechanism of competition law in UK. And the CMA can accept binding commitments or approve voluntary, redress for competition law breaches. And now I would like to discuss about what does UK competition law protect against. So mainly you have to keep in mind two things. First one is anti-competitive agreements and abuse of dominant position in the market. So the competition law is designed to stop these two main activities in a market. So they are anti-competitive agreements and abuse of dominant position. And if the competition law always protect the consumers and the business and all the transactions from unfair or abusive anti-competitive practices by providing access to competitive markets, resulting in business having equal rights in. So the entry and exit barriers should not be there. There should not be any abuse of dominant position. There should not be any anti-competitive practices. If it is there, then the CMA is having the regulatory authority which has the power to take actions. And what is competition law in UK? So regarding competition law is concerned with agreements or practices which actually or potentially distort competition within a market in a way which is ultimately detrimental to the consumer. So we have to keep in mind that, the consumer, the ultimate, beneficiary, the consumer should not be affected due to all the malpractices or due to the anti-competitive nature in the market. So the UK competition rules mainly focuses on certain things. That's mainly the objectives of UK competition law. The first one is the prohibiting agreements or understanding between the competitors that are likely to prevent or restrict the competition. So we have to make sure that we have to prohibit such agreements or such understanding between the competitors that are likely to cause or prevent the competition in the market. So that means we have to restrict the monopoly in the market. The second point is that prohibition of certain so-called abusive practices by any business which enjoys a very strong market position, says that it can act without regard to its customers or competitors or the suppliers. So we have to make sure there is no abusive practices or unfair trade practices in the market. Third point is that prohibiting or modifying mergers, acquisitions of business or assets, creation of joint vendors and so on. So if it is not following the regulatory mechanism and if it is causing a serious threat or discriminatory practice which is detrimental to the market. And also, such transaction may trigger the merger controls of the UK competition and CMA, where the parties involved meet certain thresholds. And the next point is that where the competition across a particular market do not appear to be functioning effectively, the authorities have the power to review the whole market and investigate on the matter and to take a decision to give penalty and so on. And next point is that preventing the grant of a subsidy that is likely to distort competition unless the subsidy falls within one of the exceptions. That is a situation that can lead to an unfair trade practice and which can be, penalty can be imposed based on this. And next area is civil and criminal penalties. If there is an anti-competitive nature, if there is abuse of dominant position, what are the penalties? So any infringement of UK competition law would have serious consequences. The first point is that in the UK, it is a criminal offense for an individual to enter into an agreement between competitors to rig bids, to fix price, to form cartel, to fix the pricing, to have abuse of dominant position, and so on. So we generally term, and the umbrella term is cartel offenses. So if there is cartel offenses which is causing a detrimental effect, then that is actually a criminal offense. So if somebody is doing such a cartel offense, then the conviction for the cartel offense carries within it a maximum penalty of 5 years imprisonment and or an unlimited fine. And also the UK Competition Authority have powers to impose very significant fines in business found to be breach of competition rules, so which can be up to 10% of worldwide aggregate group turnover under UK competition law. And also, we do have contractual restrictions. If there is a contractual restriction that infringes or breaches competition law, will be void and which will be unenforceable. We cannot enforce it through court. That's the meaning of that. And also, the directors of UK companies, if that have infringed UK competition law, may be disqualified from acting as a director up to 15 years. And also the business personnel of the companies that may incur fines for failing into comply with procedure requirements. And also there is a criminal liability which is punishable, even which can be fines or prison sentence to up to 2 years, where they obstruct an investigation by CMA. The next point is that third parties may be able to sue for damages where they have suffered any loss as a result of any prohibited anti-competitive agreements or practices in the UK based on the competition law in UK. Next point is that also they do have a practice of publishing such newses so that they can even spoil the reputation of the business. So this causes a damage to the business reputation. So all is where the criminal and civil penalties, and next is investigation. Regarding investigation, CMA is having the ultimate authority to do investigations. CMA is vested with the power to conduct investigation of business, to understand if there is any anti-competitive practices, to know whether there is an abuse of dominant position. And also, in addition, CMA has powers to interview individuals who are connected to business under investigation. So this is a in short idea about UK competition law, the objectives, the scope, the regulatory mechanism, the CMA, and so on. So in today's class, I have discussed about UK competition law, antitrust laws in UK, CMA, the regulatory authority, UK competition law, CC, the competition commission in UK, the penalties, the fines, the imprisonment, then regarding, all other mechanisms, scope and objectives of UK competition law. I hope it's clear for you. If you do have any doubt, do comment below. Thank you for listening to me.